Hello, folks. Hello. Not sure why I played that first. So that was kind of productive. So I got to get out of here by at least by 4:30. I thought I had an appointment at 2:30, so I'm gonna dedicate this live to Debo. Oh, Lord, you done came so quick. Okay. Lord, I didn't think it was gonna come that quick. I'm online. Yeah, I've seen that. Yeah, it is hot. This is what you think. Yeah. It's yeah. It's two of them. Yeah. You need to eat you something. You need to eat a little meal or something. How much you?
Where you want to go? Where you want to go up there and throw all these fruits and vegetables and stuff that be heavy as all get out?
Yeah, but
I ain't
God,
gonna lift them up.
I know what the hell they got to do with you eating a piece of bread or something?
I eat.
Your ass is usually talking about me small. Your ass is little, honey. Your ass is little. Yeah, you are little. And I thought you said you weren't gonna be putting color in your hair and shit.
Not like wild colors.
Okay, well I'm in no pink and blue hair and stuff like that because I'm not playing. Okay, well let it stay right there. That's enough. It's cute though, but it's enough.
Oh, yeah,
This is enough. I don't want to see no pink hair and pink ends and shit.
you know, pink. I don't even like pink.
Okay, but don't do that. Don't be on the Instagram twerking, and don't be on the pole. That's mama's worst nightmare. All right, then. Love you. Thank you. Sorry, y'all. That was my child. But yeah, so what y'all looking at in the middle, they just started a Twitter page for Debosky. And let me show you. So if y'all can go and sign up for that, that'll be most graciously appreciated. Yeah, let me show you. That is the Twitter page. Can y'all see it? Yeah, there we go. That's the Twitter page. That is his Twitter page. All right, everybody got it? If not, y'all can go back and screenshot it. All right, now let me put the paper. So we in Illinois today. Child, they is doubling up on R. Color. Yeah, we have so many opportunists out here. It's just ridiculous, honey. It's just ridiculous. I ain't gonna say no more, but if you know me, you know what I'm saying. What I ain't really got to say it. You know what I'm talking about. Mm. Anything for some attention, likes and views and subs. I tell you anything. Mm, 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 mm. Mm. If y'all want to know where I do a lot of my sneak dissing at when I'm not on live, I do it on the community board. I do it on our community board. A lot of times people talk about, Andrew, what you talking about? All you need to do is just look to see what's going on now. And if you see me having a comment during what's going on now, you know that's what I'm talking about. A lot of people, God damn, I swear I could probably have about 10 whispers or whatever, because yesterday people was like chiming in knowing exactly what I was talking about when I was talking about like oh shit. Oh, I ain't get a chance to holler at some of y'all, boy. I forgot my duties. Oh, what's good with it? Hey, let me see who up in here. Who was first at least? Ooh, was a lot of folks. Okay. Oh my goodness. What is this live view? What is this? Oh. Hey, Miss Sheena, number 2. Woo, you was first. Hey, the hell you in the bushes cooking? Giving the bushes hell. Hey, Justin Shelton. Hey, Ruth Wilson. Hey, Demetrius Bradley. Hey, Alicia. Lavelle. Give him hell of a hey, y'all. Hey, y'all. Hey, Leslie Jennings. L. Littleton. What's good? What's good? What's good? Hey, Ruth Wilson. Red. Hey, Dolores. Nobody's food was good. Hey, Lady Tech. Fresh ain't dead. What's up, Fresh? Did I do wellness check on? Levi put that video up. Hopefully, we'll get a sighting of Levi sometime soon. Hey, Regina White. Hey, stilettos for me. Lady G, that's right. Free D Boski. Hey, James Harris. Shut up, James Harris. Hey, Faith. Hey, it's your girl TY. What's good with it? It's your girl Ty. Queen. Hey, Love's Fair. Uniquely. Hey, stop 123. Hey, Miss Reddy. Miss Reddy, are you ready? What's going on? Hey, Queen, everybody. QE. Back to life. Back to the. We had. McDime, dime. Do, 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 do. Looking for McDime. Top of the line. Okay, so the judge in Illinois, he had to come on. He wanted a piece of the action too. So come on here, Harry Lynn Weber. So remember I told you, I'm not on the screen anymore. Remember I told y'all that this judge likes to handle a couple things at once, whatever, right? All at one time, either on a phone call or in his oral orders or however he likes to do it. So that's what he's done here. I'll go ahead and read it. It's not that long. It says order. Before the court is defendant's motion to dismiss counts 1 through 4 and counts 6 through 13 of the superseding indictment. Also before the court is defendant Kelly's motion to sever. For the reasons stated herein, the motions are denied. Okay. A. Motion to dismiss. On February 13th, 2020, the government filed a superseding indictment charging defendant Kelly with 13 counts, defendant McDavid with 4 counts, and defendant Brown with 1 count. Defendant McDavid previously moved to dismiss count 5. This court denied that motion. On May 2nd, 2022, defendants filed another motion to dismiss, arguing that all counts except count 5 should be dismissed. Defendants argued that the counts are untimely and barred by the statute of limitation. 1. Counts 1 through 4. Counts 1 through 4 of the indictment charged defendant Kelly with producing 4 videos of a minor engaged in sexually explicit conduct and violations of 18 U.S.C. Section 2251, A. The indictment states that the videos were produced between 1998 and 1999. At the time of the charged conduct, the statute of limitations expired once the minor reached the age of 25. 18 U.S.C. Section 3283 in 1994, amended in 2006. And remember when we were trying to figure out if J-Bo had a leg to stand on, we discovered just that it was amended in 2006. So we said at that time, he's probably going to deny it, which he did. It says, Kelly argues that as a result, these counts are time barred. In response, the government argues that the limitations period was extended when the statute was amended, and the extended date should apply. 18 U.S.C. Section 3283 was amended in 2003, extending the statute of limitations to the life of the minor. 18 U.S.C. Section 3283, 2003, amended in 2006. The statute was amended again in 2006, extending the statute of limitations to the life of the child or 10 years after the offense, whichever is longer. 18 U.S.C. Section 3283. If the operative limitations period is the one set out in the 1994 version of the statute, counts 1 through 4 expired in 2009. If the amended statute of limitation applies, the counts are timely brought. The Supreme Court has set out a 2-step test to decide whether a federal statute applies to past conduct. Landgraf versus USI Film Products, 511 U.S. 244 and 280 in 1994. The first step is to determine whether Congress has expressly prescribed the statute's proper reach. If the statute's proper reach is clear, the inquiry ends there. However, if the statute is silent, the next step is to determine whether applying it retroactively would impair a party's rights. Defendants urge the court to look at the legislative history of 18 U.S.C. Section 3283 and rule that Congress expressly prescribed that the statute does not apply retroactively. Defendants points to the House version of the bill, which contained an express retroactively provision. Child Abduction Prevention Act, H.R. 1104, 108 Congress Section 202 in 2003. The final version of the bill omitted this provision, and Senator Leahy confirmed that the omission was intentional. Senator Leahy, Amber legislation, Congress Record 149 and 50, Section 5147 in 2003. Judge Nathan of the Southern District of New York recently dealt with this precise issue in the prosecution of defendant Ghislaine Maxwell, United States versus Maxwell, at 534 Federal Supplement 3, 3rd edition, 299 in the Southern District of New York, 2021. There, Judge Nathan analyzed 18 U.S.C. Section 3283, finding that Congress not only permitted but intended 18 U.S.C. Section 3283 to allow prosecutions for past conduct for which the statute of limitations had not expired. Right. The court agrees with Judge Nathan analysis. With each amendment to 18 U.S.C. Section 3283, the statute of limitations increased. In light of the lack of retroactivity provision, but steadily increasing statutes of limitations, the court finds that the statute does not prescribe its proper reach. The court next moves to the second step of the Landgraf test. The court finds that applying the current version of 18 U.S.C. Section 3283 would not impair the defendant's right. In the Seventh Circuit, applying procedural statutes, which effectively enlarge the limitations period, does not violate the ex post facto clause as long as the statute is passed before the given prosecution is barred. So what the ex post facto clause is, as long as you amend, make changes to statutes before they expire, right, become time barred, then you're not violating the ex post facto, right? When it's ex post facto states that when you implement new laws on the state and federal levels. Sorry about that, y'all. State and federal levels. Then the post ex facto does not will not be allowed in that. But as long as you do it when crime before law expires, then you're fine. So I've explained this several times, so if I need to clear it up, I will. Let's see, where was I? Oh, U.S. versus Gibson, 490 Federal 3rd, 604, 609, 7th Circuit, 2007. I don't know why I'm reading that. I'm off. I'm reading all those numbers. Woo! Okay, citing Stronger versus California, 539 U.S. 607, 2003. However, in their motion to dismiss, defendants urged this court to read the second step of Landgraf as providing broader protections for criminal defendants than the ex post facto clause. Reference. The court declines to do so. Oh. Damn, he rude. Applying the current version of 18 U.S.C. Section 3283 does not impair any of the defendant's rights because the statute was amended before the original limitations period expired. This court will not disturb well-settled law to create new statutory rights where none currently exist. Courts 1 through 4 are timely. Oh, wow. Well, I don't know if I need to explain what he's saying. He's very rude, this judge is. He's saying that, hey, it's like he's taking it as if she's asking him to do something that doesn't need to be done with regards to this law, like write something extra in it so it would make her particular motion valid, and one that they should look at and expound upon, and maybe move it for what have you, maybe create case law out of it. You understand what I'm saying? But he's saying that it is a real written piece of legislation which tells you exactly what it should be and how to handle it. So he's saying he's not doing it. Damn, you rude. Count 6 through 8. Count 6 charges all defendants with conspiring to receive child pornography in violation of 18 U.S.C. Section 2252A, A2, and B1. The indictment states that the conspiracy took place between 2001 and 2007. Count 7 charges defendants Kelly and McDavid with receiving 2 videos of child pornography in violation of 18 U.S.C. Section 2252A. The indictment alleges that Kelly and McDavid received these videos in August 2001. Count 8 charges defendant Kelly and McDavid with receiving 1 video of child pornography in violation of 18 U.S.C. Section 2252A. The indictment states that Kelly and McDavid received this video in April 2007. Defendants argue that counts 6 through 8 are subject to the general 5-year statute of limitations and are now untimely. 18 U.S.C. Section 3282 stating that unless otherwise provided by law, the statute of limitations for a non-capital offense is 5 years. The government argues that the court should apply the statute of limitations set forth in 18 U.S.C. 3299. According to 18 U.S.C. Section 3299, there is no statute of limitations for an offense under Chapter 110 of the Title 18 of the U.S. United States Code. Count 6 through 8 all charge defendants with violations of Section 2252, which fall under Chapter 110 of Title 18. As such, Section 3299 applies to counts 6 through 8. Section 3299 became effective on July 27, 2006. The court finds that counts 6 through 8 are timely. First, count 6 through 8 of the indictment both states that the conduct in question concluded after 18 U.S.C. Section 3299 was enacted. Therefore, 18 U.S.C. Section 3299 clearly applies, and a prosecution for these counts can be brought at any time, including in the current indictment. The accused conduct in count 7 took place before 18 U.S.C. Section 3299 was enacted. The court applies the Landgraf test to this count. In the first step, the count finds that the text of 18 U.S.C. Section 3299 is silent as to its proper reach. In the second step, the court finds that applying the statute would not impair the defendant's right. In drawing this conclusion, the court once again applies Gibson 490 Federal 3rd 604, 18 U.S.C. Section 3299 was enacted on July 27, 2006. The parties dispute what statute of limitation applied to count 7 during the time of the accused conduct. The defendants argue that count 7 is subject to the general 5-year statute of limitations, 18 U.S.C. Section 3282A. The government argues that the limitations period extend until the relevant minors turn 25, as specified in 18 U.S.C. Section 3283. The court notes the dispute is largely irrelevant here. Either way, Count 7 is timely, applying the shorter limitation period of 5 years. The statute of limitation would have expired in August 2006. As 18 USC Section 3299 was enacted before the original limitations period expired, there is no ex post facto problem. Again, ex post facto, if there was a problem, meaning like the law had expired and a new law was created. When a new law is created for state and federal, then you can't add ex post facto, but you can do it before a law expires. So that's what he's trying to say. So the reason why the ex post facto thing is important is because it makes the crimes retroactively. Okay, it goes back. So there is no ex post facto problem, meaning defendant's rights are not infringed. And it says Gibson 490, Federal 3rd at 609. The court applies 18 USC Section 3299 here. Count 7 is timely. Number 3, counts 9 through 13. Counts 9 through 13 of the indictment charge defendant Kelly with knowingly enticing minors to engage in sexual activity in violation of 18 USC Section 2422B. In addition, counts 9, 10, 12, and 13 charge defendant Kelly with aggravated criminal sexual abuse in violation of 720 Illinois Code, ILCS shit, 5/12-16D. The indictment states that the activity occurred between 1996 and 2001. Like with charges 1 through 4, 18 USC Section 3283 provides the relevant statute of limitations. At the time of the accused conduct, the limitations period expired when the minor turned 25. The earliest date at which any minor in the accused conduct turned 25 was August 2005. As discussed earlier, 18 USC Section 3283 was amended in 2003, extending the limitations period to the life of the child. Earlier in this order, the court analyzed the applicability of the amended version of 18 USC Section 3283 to counts 1 through 4 of the indictment. The analysis for counts 9 through 13 is largely the same. Applying the first step of the Landgraf test, the court finds that 18 USC Section 3283 does not explicitly prescribe its proper reach. In the second step of Landgraf, the court applies Gibson. Defendant Kelly's rights are not infringed because 18 USC Section 3283 was twice amended before the previous limitations period for counts 9 through 13 expired. The court applies the current version of its 18 USC Section 3283 to counts 9 through 13. Counts 9 through 13 are timely as well. In sum, the defendant's motions to dismiss is denied in its entirety. Okay. So all of that I just read, we in Jennifer Bonjean's motion, as you can recall, she was going at the time of filing, and she also wanted the judge to take a look at what she felt that did not have either the procedure in which to follow the law wasn't there or it wasn't clear. So she asked Judge Linenweber to also look at that and then make a ruling as well based on that, right? That would have, he would have, if he would have gone through and done all that, whatever, that would have created, case law. Every case don't create case law, okay? It doesn't. Case law is based on rulings when you got to step outside of the law. It's not the final result of a case. I mean, all cases, no. That's not what case law is. All right. B, motion to sever. Defendant Kelly has also filed a motion to sever. Kelly requests that defendant McDavid be tried separately and that counts 10 through 13 be severed from the rest of the indictment. Federal Rule of Criminal Procedure 14 authorizes district courts to order separate trials of counts, sever defendants' trials, or provide any other relief that the justice requires. So I remember I told you, before you start getting to severances and stuff like that, they're gonna come through with a remedy. All right, Federal Rules of Criminal Procedure 14. District courts have discretion to grant the relief they deem proper, whether that is severance or something less drastic, such as limiting instruction. In cases involving conflicting defenses, severance is not required, even if prejudice to a defendant is shown. A court must only grant severance if there is a serious risk that a joint trial would compromise a specific trial right of one of the defendants or prevent the jury from making a reliable about judgment about guilt or innocence. That's how he wrote it. 1. Severing defendant McDavid. Defendant Kelly urges that defendant McDavid should be tried separately because of antagonistic defenses and because one of McDavid's lawyers may have a potential conflict of interest. In the motion to sever, Kelly alleges that both he and McDavid may present evidence against each other. Kelly alleges that he intends to present evidence that McDavid controlled the purse of the operation and pushed Kelly to continue to work to keep the money flowing. Kelly also alleges that McDavid might be used as a witness against him. Kelly's allegations do not provide further detail. Kelly argues that severance is required because he intends to show that McDavid had an interest in Kelly continuing to work. However, as the government points out, this evidence is not necessarily antagonistic to or even inconsistent with McDavid's possible defense. It is entirely possible that McDavid pushed Kelly to continue working and also conspired with Kelly to conceal misconduct. As presented, Kelly's motion reads to blame shifting. Wow. Blame shifting among co-defendants does not mandate severance. True. Moreover, Kelly does not specify exactly what evidence he expects to present that will compromise any of McDavid's trial rights, nor does he specify what evidence he expects McDavid to present that will be used against him. The motion does not raise any serious risk of impeding defendant's trial rights or that a jury would be prevented from making a reliable judgment. Kelly next argues that McDavid's lawyer, Vadim Glossman, may have a conflict of interest. Kelly retained a lawyer named Ed Jensen to represent him in a criminal case resulting in Kelly's acquittal in 2008. Reference. Between 2008 and 2018, Kelly frequently consulted with Jensen. Glossman was an associate at Jensen's firm from 2014 to 2018. Kelly argues that through this connection, Glossman may have privileged information that could be used to Kelly's detriment. Glossman denies that he has any privileged information about Kelly. Glossman stated that his only conversation with Kelly and the first time he met Kelly was at Kelly's indictment hearing for this case. Kelly does not identify any privileged information or any class of privileged information that he alleges Glossman accessed. Kelly submitted a declaration on his own behalf where he states that he does not have a specific member of Ever consulting with Vadim Glossman. All Kelly offers is that he has a distinct memory of Glossman, name of someone who worked with Mr. Jensen. Kelly has not presented sufficient information to show that Glossman has an actual conflict of interest. The court will not sever McDavid's and Kelly's trial. Number 2, counts 10 through 13. Kelly argues that counts 10 through 13 should be severed from the rest of the indictment because he will suffer substantial prejudice otherwise. Sorry about that. That's my reminder that I got to get out pen out. Severance may be warranted if a defendant is improperly coerced into testifying about a count on which he wishes to remain silent. Case law. The Seventh Circuit of 2013, when a defendant seeks to sever charges because he wants to testify to some charges but not others, he must show that he has a strong need to testify on one count but not the other. Kelly alleges that the evidence in support of counts 1 through 3 is stronger than the evidence in support of counts 10 through 13. Oh wow! So they are saying that the taped evidence is stronger. Hmm. No, no, I read that before, and I'm just zeroing in on it. They are saying that the evidence with the tapes is stronger. No. In support of his argument, Kelly states that counts 1 through 3 are supported by video evidence. If I would have kept on, I would have. Shit. Okay. While counts 10 through 13 are supported by testimonial evidence. Right. Kelly argues that he has important testimony to give concerning counts 10 through 13 and need to refrain from testifying as to counts 1 through 3. Okay. Damn. All right. Reading this shit, you get insights into what's going on. All right. So it looks like he ain't fucking around with them tapes. That's not to mean, that's not to say that he's not going to put on a defense about it or anything like that. That is not what I'm saying. That is not what I am saying. What I'm talking about is that he pretty much saying he's not getting up there to testify about that. Because here's the thing, right? Once a defendant testifies, he has to testify to the entire thing. He cannot uh, take the fifth on certain questions. Now, a regular witness can. You can answer the questions that you plead the fifth on certain questions you don't have to. But if he takes the stand, he got to plead the fifth on everything or nothing. So it's all or nothing. So he said he ain't fucking around with them tapes. Kelly's motion to sever does not specify exactly how he will be prejudiced if all the counts are tried together. Kelly does not adequately explain his assertion that the evidence in support of counts 1 through 3 is stronger than the evidence in support of counts 10 through 13. Kelly claims that the video evidence is much stronger than the testimonial evidence of questionable veracity, but fails to provide more detail. Further, Kelly's motion fails to present evidence showing why he has a need to testify on only some of the counts. Kelly's motion asserts that severance is warranted, but does not provide specific evidence in support of that assertion. For that reason, the court denies Kelly's motions to sever. For the reasons stated herein, defendant's motion to dismiss and Kelly's motion to sever are denied. And that's by Judge Lynn and Webby. Give me a minute and I will be around to the front. check in real quick. Okay. All right. All right. I'm around the front. I'm around the front. So, huh. What can we say about that? Trying to see where she could go. Let me look at this paperwork real quick. Okay. See, if just say if he took the stand and excuse me, I'll try to defend himself against his co-defendants with regards to the conspiracy part of it. What would he? What I mean, unless well, actually, he really doesn't have to do that. All he has to do is submit evidence that if he is going to throw McDavid or Brown up under the bus or whoever, all he has to do is submit that evidence. It's up to him if he wanted to testify or not. I don't see how him testifying to those counts 10 through 13, I believe, would. I mean, of course, it looks. Well, here's the thing: you kind of would kind of be fucking your own self up because you know that prosecution is coming. They get to talk to you, so you get your ass up on that stand if you want to. They're gonna come and talk to you. So his best bet, just in my opinion, is to stay in that seat and just let her submit the evidence to shows that whatever you're trying to illustrate with regards to Daryl McDavid's larger role, and the diminishment of your role. If the judge didn't find it necessary to make a big old situation. I don't know how if he's going to still go through and try to get three separate juries and stuff like that. I don't know if he's going to do that for them as a remedy to prevent like a severance or whatever. I'm not sure what would be his final disposition with regards to how to do that jury. So we saw from paperwork that they are keying in on that jury. They're trying to do everything to prevent a severance. So let me see what y'all talking about in here. Wasn't. Do you think SL? Who was SL Candy? Get some of y'all comments. Oh, this guy. I'm trying to tell you, I am burning up. Man, is this? No, I was hot. What's up, Star? What's up, Star? I'm trying to see what um okay, I see y'all having some chat business. I'll stay out of it because I don't know what's going on. Susan Loggins. Oh, okay. Well, we don't know if there is some evidence that's coming in that will have anything to do with Susan Loggins. So that would be number one why she probably wouldn't be called. And if it is, it could be evidence that's strong enough to stand alone without any cooperation. So listen, this is another rough one. I'm just gonna be honest. You got to be honest right here. I would have felt horribly if I was around here giving y'all false hope and all that bullshit. You know what I'm saying? You do your prayers and all of that. You do that, but I'm not gonna come out here and read something that I know ain't is bad for whatever side it is, and sit up and try to, I'll try to find the, I'll be trying to find the legal good and bad out of whatever I read. But I'm not gonna sit up here and tell you, give you like a one sided, yes, yes, positive. No, no, that's stupid. And you're gonna come out there, and then to me, people aren't worried about their credibility in the damn streets. People volunteer to lie and shit like that. And let me tell you something. The men and the women that prosecuted that case, that defended that case, they are the ones that did the work on that case. We ain't do shit. They did the work on it. And it's a lot of motherfucking work. I've been there and done that. It's a lot of work. Day in and day out. And that's not the only case you be having. Be having several. Going at one damn time. Well, hopefully everybody got that my avatar. That's the screenshot of what's the thing on Twitter. That's the Twitter thing. So make sure y'all go there and like and share it, and make sure you follow it. I'm gonna have to figure out. So we got I don't know, his hearing, his telephone hearing is tomorrow at noon. And if let me give y'all the numbers, y'all can call in. Make sure as many people as possible. If y'all can get down there, please make sure y'all go and listen. Go in the courtroom. If you can get down there, let me give it to you. I don't know what Karen is. And the code is let's 7 Okay, I'll put it up here. Okay, 877-336-8039. The code is 433213. All right, and that's for Debo. Make sure y'all get that. You're welcome. You're welcome. You're welcome. So, I got about 30 more minutes. Hey, I'm so used to doing these long ass lives. I'm like, shit. Oh, man. I mean, the paperwork was pretty cut. Pretty much cut clean, you know. Let me see. So, but I did a whole thing explaining ex post facto. So, let's see. So, I told you. Remember, I told y'all that J-Bo likes to put pressure on the law, put pressure on the judge, put pressure on everybody to kind of. And I foresee her with her her subsequent request. It's going to be asking people to come, you know, of course, look at the law, but look at the law in a broader sense, right? And make more rulings based on your feeling of what's fair and what's right, other than just what the law states. But that's going to be a hard hurdle to cross if she comes up against a law that is plainly stated. The language has no ambiguity in it, and the language is not contradicting none of that. So it's going to be hard, very hard for her to overcome overcome those objectives. And you got to understand, I think she does a lot of civil rights, constitutional rights, and so with those type of attorneys, they look for shit this ain't right to them. With the law, it just ain't right. And so we just, you can't go to the judge. You're like, I just don't feel it. This just ain't right. So, oh my goodness. So if it has no, no ambiguity in there, it's not contradicting, none of that, she's going to have a problem because her mindset is on rights, disparities, white people, white people against black people, treatment, all that type of stuff. And when you have some of these laws that are legally, I mean, plainly stated, it may, she may have a problem. She may be more successful as it goes to an appeal. Just say if something happens, whenever she goes to appeal. I'm not saying, this thing is going to end in another conviction. What I'm just saying, anytime she goes up, she may have more leeway and more room to argue those type of things. Because there, they will take a deeper look into the law. Okay, at that level. They will. But here, I don't know if her strategy is going to win much motions or anything, right? And here's the thing, right? I think at this run of it, I think most of these motions will be it's going to be I don't know if we'll see R. Kelly spearheading a lot of these motions like we did with the New York case. Because I think he trusts her and I think that she could take what he's wanting and put that in a way to where it has a legal basis, you know. And I don't think we're gonna see any emotions about he want to get out and go home to his girlfriend. Well, I don't think we're gonna see that. What you talking about, Yellow? A request to the judge? I don't have that. I don't have that. Where is that? Where is that? Yellow. Oh, okay. Wait a minute. Shit. Wait a minute. Are you talking about this order? Yellow. Let me know if you're talking about this. It says defendant reports that he wishes to exercise his rights to have a preliminary examination hearing in charging district. In charging district. You talking about that? Oh, let me see if I should go somewhere else. Wait a minute. Let me see if I should go somewhere else. Is this in the system? Well, I don't know why I can't now get stuff on this board. Let me see. Okay, I don't know why I can't find none of this. Where you is anybody telling me? Did I read it right? That's what I'm talking about. Okay, okay, yellow. Okay, all right. So I guess on the phone call tomorrow, I guess this says happened on July 1st. So I guess on the phone call tomorrow, we'll be able to hear exactly what the prosecutors have. Who did he require this? Yeah, okay. He requested this. Go ahead on. Lawyer Debo, Attorney Debo. Yeah, he requested it. So he's asking them to show them what do they have in order to charge him. What do you have? So depending on how the judge think that there was enough probable cause based on what the prosecutor submit, they can either he can either say yeah, it's enough probable cause to detain you, to charge you, or to let you go. Right. So yeah, so Debo requested it. So that's what you want, Mirror. Okay. Oh, Somebody said the welfare office. Is somebody in here under the welfare office? I'm not gonna be playing with y'all all day. What's up, Jennifer? Hey, Carlos. Rick James, bitch. That Faith, Karen J, Lisa Jones, Love Spell, Love Spell. I think I got Queen. Everybody. Yes, so I am not finna play with nobody that's in here under the welfare office. I'm not finna do that. I'm not playing with you. Right, Queen. That is some crazy shit. Like you got him, but I mean, I hope he tells his the person who's representing him that was he got video showing that he's saying we did 10 rounds a day. We're gonna double it up. The double up meaning the stamina. And nothing do no bullets and ammunition. Y'all got to pull those videos or reference those videos. The people on his team referenced those videos during the time when they was doing the protests and stuff like that. And he was saying, we're gonna double up tomorrow. We did 10 rounds a day. We're gonna do 20 tomorrow, and all of that. Ain't got nothing to do with no bullets. Those that right there, that's two competing sets of evidence talking about the same subject. Yeah, somebody need to dig that out and give it to his PD. Oh well, okay, wait a minute. The judgment came out. I guess I can read that before I get out of here. Oh, thank you, Lord. Be giving me the paperwork when I'm still alive. I got about 15 more minutes. And I got to get. I got to get. I got to get ready. People in there talking about how me and JoJo was arguing, talking about that's love right there. I was like, y'all silly. Y'all silly as hell. Ooh, 8 pages. Ooh. Can I do it? Can I do it? Okay, this is just um I'll flash it on the screen just in case y'all want to take shots. So hold on. Let me put it on the screen and I'll run that by. For the people that don't have pacer, I will do that. All right. So this is his order from New York. All right. Remember I told you those S's mean that's just the number of time the indictment has been superseded. Those S's. That's what it stands for, the S's. Yeah, supervised release for 5 years. Mandatory condition. Oh, well, I can look at the mandatory conditions. Okay, his you must not commit another federal, state, or local crime. You must not unlawfully possess a controlled substance. You must refrain from any unlawful use of controlled substance. You must submit to one drug test within 15 days of release from imprisonment and at least two periodic drug tests thereafter, as determined by the court. And then it says he had a box checked here. You must cooperate in the collection of DNA as directed by the probation officer. And no, this is all about his supervision when he gets out. Okay, wait a minute. All right, well, I'm probably gonna read this. Let me see. Okay, special conditions of supervision. Number one, the defendant shall comply with any applicable state and or federal sex offender registration requirements as instructed by the probation officer, the Bureau of Prisons, or any state offender registration agency in the state where he resides, work, or is a student. Number two, the defendant shall participate in a mental health treatment program, which may include participation in treatment program for sexual disorders as approved by the United States Probation Department. The defendant shall contribute to the cost of such services rendered and or any psychotropic medications prescribed by to the defendant to the degree he is reasonably able and shall cooperate in securing any applicable third party payment. The defendant shall disclose all financial information and documents to probation department to assess his ability to pay. As part of treatment program for sexual disorders, The defendant shall participate in polygraph examinations and or visual response testing to obtain information necessary for risk management and correctional treatment. Number three, the defendant shall not associate with or have any contact with convicted sex offenders unless in a therapeutic setting and with the permission of the United States Probation Department. Number four, the defendant shall not associate with children under the age of 18 unless a responsible adult is present and he has prior approval from the probation department. Prior approval does not apply to contacts which are not known in advance by the defendant, where children are accompanied by a parent or guardian, or for incidental contacts in a public setting. Any such non pre approved contacts with children must be reported to the probation department as soon as practical, but no later than 12 hours upon I can't see none of that. Commencing supervision, the defendant shall provide to the probation department the identity of contact information regarding any family members contacted, and the probation department can approve routine family and social interactions such as holidays and other family gatherings where such children are present and supervised by parents or guardians without individual approval of each event. Number five, if the defendant cohabitates with an individual who has a minor children, the defendant will inform the other party of his prior criminal history concerning his sex offense. Moreover, he will notify the party of his probate. What is that? Prohibition of association with any children under the age of 18 unless responsible adult is present. Number six, the defendant shall report to the probation department and any and all electronic communications service accounts as defined in 18 USC section 2510 at 15 used for user communications, dissemination and storage of digital media files, i.e., audio, video, and images. This includes, but not limited to, email accounts, social media accounts, and cloud storage accounts. The defendant shall provide each account identifier and password and shall report the creation of new accounts, changes in pass identifiers and passwords, transfers, suspension, and or deletion of any account within 5 days of such action. Failure to provide accurate account information may be grounds for revocation of release. The defendant shall permit the probation department to access and search any accounts using the defendant's credentials pursuant to this condition only when reasonable suspicion exists that the defendant has violated condition of his supervision and that the accounts to be searched contains evidence of this violation. Failure to submit to such search may be grounds for revocation of release. Number seven, the defendant shall submit his person, property, house, residence, vehicle papers, computers as defined in 18 USC section 1030C1, other electronic communications or data storage devices or media or office or to search conducted by a United States probation officer. Failure to submit to a search may be grounds for a revocation of release. The defendant shall warn any other occupants that the premise may be subject to searches pursuant to this condition. Any officer may conduct a search pursuant to this condition only when reasonable suspicion exists that the defendant has violated a condition of his supervision and that the areas to be searched contain evidence of this violation. Any search must be conducted in reasonable time and in a reasonable manner. Number eight, let's have this shit. 8. The defendant is not to use a computer, internet capable device, or similar electronic device to access any visual depiction as defined in 18 USC section 2256, including any photograph, film, video, picture, or computer generated image or picture, whether made or produced by electronic, mechanical, or other means of sexually explicit conduct as defined in 18 U.S.C. Section 2256. The defendant shall also not use a computer, internet capable device, or similar electronic device to review images of naked children. The defendant shall not use his computer to view sexually explicit conduct or visual depictions of naked children stored on related computer media such as CD or DVDs, and shall not communicate via his computer with any individual or group who promotes the sexual abuse of children. The defendant shall cooperate with the United States Probation Office Computer and Internet Management Monitoring CIMP program. The cooperation shall include but not be limited to identifying computer systems as defined in 18 U.S.C. Section 1030E1, internet capable devices, and or any electric media capable of data storage the defendant has access to, allowing an initial examination of the devices and installation of monitoring software hardware on the devices, and the geolocation of the device. The geolocation means like where it is with respects to the globe, the world. The probation office may access the device and or data captured by the monitoring software hardware at any time with or without suspicion that the defendant has violated the conditions of supervision. The defendant may be limited to possessing only one personal internet capable device to facilitate the devices and any electronic media capable of data storage for further analysis by law enforcement or the probation officer based upon reasonable suspicion that a violation of a condition of supervision or unlawful conduct by the defendant has or is about to occur. Failure to comply with the monitoring seizure and or search of any computer system, internet capable device, and any electronic media capable of data storage may result in adverse action such as sanctions and or revocation. The defendant shall inform all parties that access a monitor, what is that, monitor device that the device is subject to search and monitoring. Number nine, the defendant shall refrain from contacting the victims of the offense. This means that he shall not attempt to meet in person, communicate by letter, telephone, email, the internet, or through a third party without the knowledge and permission of the probation department. Number 10, the upon request, the defendant shall provide the United States Probation Department with full disclosure of his financial records, including commingled income, expenses, assets, and liabilities, to include yearly income tax returns, with the exception of the financial accounts reported and noted within the pre-sentence report. The defendant is prohibited from maintaining and or opening any additional individual and or joint checking, savings, or financial accounts for either personal or business purposes without the knowledge and approval of the United States Probation Department. The defendant shall cooperate with the probation officer in the investigation in their financial dealings and shall provide truthful monthly statements of their income and expenses. The defendant shall cooperate in signing of any necessary authorization to release information or forms permitting the United States Probation Department access to their financial information and records. Number 11, the defendant shall comply with any possible restitution order. And that's the restitution order there. It's a $900 assessment, $100,000 fine, and $40,000 JVTA assessment. And Yeah, and down here, that's the following order payment should be applied. So when they recoup money, it'll go first to the assessment, first, second to the restitution. That's what it's telling you. Let me see, do he has anything? Because you know that girl, somebody wrote him a letter in jail. Do we have any non-contact orders in jail? Yeah, I don't see anything. No. Yep, back around the front, back around the front. So he got to pay. Is that $40,000 for That's for the victims. So that's $40,000. Yep. Let me see how much it was. Did that one that right? $40,000. I know I ain't crazy. Let me see. Let me see. Let me see. That's the first page of it. I know that. I just read that. I don't crack. Oh, here it is. Amended. The defendant must make restitution. The defendant made. Yeah, that's 40 grand. So let me see how they got that. So that do that come? Oh, wait a minute, y'all. Wait a minute. So for the Amy Victory and Andy child pornography victim assistance, he don't have to pay nothing on that. He just got to pay the Justice for Victims of Trafficking Act. You got to pay that. Um, yeah, he have to pay that, and then yeah, I'm gonna have to get off in a minute. So I'll have to get off in a minute, y'all. Go ahead, you can put it down.
Um,
Thank
I just gotta say something.
Sorry about that. You give me that wallet right there. I don't know what card they have on file.
She said it's a master.
Yeah, but I don't know which one. That's why I gave you that card. So I keep record on it. All right, thank you. Love you. Okay. Let me look and see when they what goes first. So they any money code comes in that it go to, for it to go to that victims fund. That's eighth. So the see how they do the assessment comes first. That's their money. Restitution principal, restitution interest, the and then victim assessment thing. That's number four. The fine principal, the fine interest, the community restitution, then the um, justice victim trafficking act thing, whatever it's called. That's eight, and then the penalties ninth, and the cost. Oh, okay, well they put themselves after that. I was going to say I always look at shit like that to see what where they head at. That bullshit, you know. I just wanted to see, just wanted to see. So y'all, I got to change my title, but I have to get on out of here because I got a meeting at 4:45. So I get my shit together. So anyway, that is I showed y'all Deboski's Twitter. Make sure y'all go over there, like, share, subscribe, follow, whatever you do, and make sure you remember he has a hearing on tomorrow at 12 noon. That's the information. Hey y'all, I need everybody to stay up, stay strong, and stay not fucking with me. Okay, y'all. I appreciate y'all so much. I do. I do. Oh, I do. Oh, I love this group. Yes. 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 All right, y'all. I might holler at y'all a little later. No problem, Faith. No problem. I'll holler. Peace out. To the next live.